Good evening, guys. So today we are going to proceed to question 2 of the 2024 November exam of professional ethics. So before I even start, you will begin to note that this question was actually lifted from a case law, which we will be discussing in a few minutes' time. But before we discuss the case law and before tackling this question, it's important that we then first understand and read and analyze the question as it was set. So without much ado, I will proceed to read the question as set. And I will do that very fast, but you have to begin so that you can identify the issues as posed by the examiner. And so, Sweezy Advocate is a sole proprietor who runs the firm Sweezy and Company Advocates. One of his most esteemed clients is Miss Rich Aunt Vibes. She is the real estate business. She pays him Kenya shillings 250,000 on a monthly basis, just in case she needs some legal work. This is being paid to date. Sweezy has been instructed by Miss Rich Aunt Vibes to purchase a property on her behalf. In the meantime, Sweezy has been getting massive amount of work. He has found it prudent to take on a partner, Advocate Snoopy. He has even changed his law firm name to reflect this status. The law firm is now Sweezy and Snoopy Company Advocates. Being quite busy, he has forgotten to inform Miss Rich Aunt Vibes that he has changed the name of his law firm. However, he introduces Snoopy to Miss Rich Aunt Vibes. He informs her that henceforth, Snoopy will take over all matters pending in the law firm. Miss Rich Aunt Vibes does not object. Snoopy takes over the purchase of the property that Sweezy had commenced on behalf of Miss Rich Aunt Vibes with aplomb. He drafts all the requisite conveyancing documents, communicates daily with Miss Rich Aunt Vibes on the status of the transaction. He even attends court for mediation on the property at some point. Finally, hooray, success! The land is transferred and the title deed issued to Miss Rich Aunt Vibes. Sweezy and Snoopy Advocates have filed a bill of costs. As they await ruling on this, Miss Rich Aunt Vibes has made an application that she is a stranger to the bill of costs filed by Sweezy and Snoopy Company Advocates. She claims she instructed Sweezy and Company Advocates. She is emphatic that she never had any agreement with Sweezy and Snoopy Company Advocates for them to do any legal work on her behalf. She is adamant that she cannot and will not pay the fees. With the aid of relevant case law, discuss the ethical issues arising from this scenario. So it's with aid of a relevant case law that you are supposed to therefore discuss issues arising from this scenario. So fellow comrades, as we have read and seen from this scenario provided above here, and the examiner is very categorical that we should answer this question by aid of a relevant case law. That statement is not there by mistake, because in fact there is a case law that was decided on the same exact facts, and this question was actually lifted from that case law. And the case law, the name is Omulele and Tollo Advocates versus Mount Holding Limited. Omulele and Tollo Advocates versus Mount Holding Limited. Now, I will not proceed to giving you the facts of the case because of time. So I will request that you do read that case on your own time. But even with that, we can now point out a few of the issues that may be arising from this excerpt that we've read and try to dissect and even answer them. And we start with the first question will be whether a valid retainer existed between Miss Rich Aunt Vibes and Sweezy and Snoopy Company Advocates. Remember, this is the new firm that was formed after Sweezy merged with Snoopy to form a partnership. So that will be the first question or the first issue. The second issue will be on the effect of change of firm name and the introduction of a new partner. The effect of change of a firm name and introduction of a new partner. The third issue will be delegation of work to Snoopy without express objection by the client. Remember, the client was informed of the delegation and she never objected to the same. So what is the effect of that? The fourth issue will be whether Ms. Rich and Vibes can lawfully claim to be a stranger to the bill of costs like she did. Remember, she filed an application in court claiming that she was a stranger to the law firm of Sweezy and Snoopy Company Advocates. So can she legally and lawfully say so? And finally, we will have the issue of the monthly retainer vis-a-vis or versus the right to a tax, the right of an advocate to tax a bill of costs. The monthly retainer fee versus the right to tax a bill of costs by an advocate. So quickly, let's dive into it. So the first thing we have to understand, we have two terms here. The first one, or rather, so the first issue will be whether a valid retainer existed between Miss Rich and Vibes and Sweezy and Company Advocates. Whether a valid retainer existed. To understand this, we first need to define the term retainer. So a retainer encompasses those instructions given to an advocate, and it can also be the fees payable thereunder. So it can be the instructions you give to an advocate as a client, or it can also refer to fees payable under such instructions. So this kind of retainer needs not to be written. It can be oral and it can be inferred from the conduct of the parties. So now let's link this definition to the current issues to see whether there was a retainer in this case. So in the present case, Ms. Rich and Vibes met Snoopy. She was informed that Snoopy would take over all pending matters. She raised no objection to the same. She communicated. So Snoopy communicated daily with this Miss Aunt Rich Vibes, and she actually allowed Snoopy to conduct conveyancing and even attend mediation. She further accepted the benefit of completed transactions, including the title that was issued thereafter. So ethically and legally, this conduct clearly evidences the acceptance of representation by the new firm. Therefore, we can say a retainer existed between Ms. Rich and Vibes and Sweezy and Snoopy Company Advocates from what we could call an inferred form or from an inferred conduct. So there was, in fact, a retainer agreement through a conduct. So it can be either through conduct, can be written, can be oral. But in this case, it was in form of conduct of the parties. And we've seen Ms. Rich and Vibes did not object to the services. So we move to the second issue on the effect of change of a firm, of the firm name and introduction of a partner. So there arises an ethical duty of disclosure in this matter. There is an ethical duty of disclosure. It's basically and ethically proper, and it, of course, best practice for an advocate to inform clients of change of a firm name, introduction of partners, and any structural organization that actually may affect the delivery or the conduct of their briefs or their cases. So Sweezy failed to formally notify Ms. Rich and Vibes of the firm name change. This raises, despite Sweezy introducing Snoopy to Ms. Rich and Vibes, she failed to formally notify this Ms. Rich and Vibes of the change of the firm name, which raises ethical questions, particularly under the fiduciary or fiduciary duty to be transparent, whereby an advocate has an obligation to be as transparent as possible, as honest as possible with their client. However, ethical lapse does not automatically invalidate a retainer, as it was held in that particular case that I started by mentioning in Omulele Tollo and versus Mount Holding Limited. The Court of Appeal held that the trial court appreciated as much and went on to hold, and rightly so, in our view, that despite the change of firm, those instructions continued to subsist up until when the respondents changed advocate. So unless Ms. Rich and Vibes could change the firm, the advocates appearing on her behalf, then that retainer actually existed. It cannot be terminated basically on the basis of non-disclosure. Thus, we conclude in this issue saying that change of the name of a law firm or introduction of a partner does not terminate an existing retainer where the client continues to give instructions and accept legal services. Therefore, where the client acquiesces, the retainer continues seamlessly. While Sweezy acted negligently in not formally notifying Ms. Rich and Vibes, conduct keyword the defect. The conduct of Ms. Rich and Vibes, who continues to receive regular updates from Snoopy, the conduct of not objecting when she actually saw this Snoopy advocate attending court in a mediation and never objected, then that conduct keyword that defects. Move to the third issue, whereby we have the issue of delegation of work to Snoopy, whereby the client did not object. So basically, one thing you actually have to acknowledge is an advocate can delegate work, and this is what usually happens. Partners delegate work to associates. However, it's important that as an advocate, you have to clearly inform your client. You have to make sure that the client is aware and is reasonably informed that of the delegation, and that the delegation does not prejudice the client, and that confidentiality and competency are maintained, so that the person you actually delegate the matter to continues to handle that brief with lots of diligence. In the instant case, Snoopy was introduced and Miss Aunt Rich Vibes raised no objection. Snoopy acted competently and diligently, and the transaction was completed successfully. Under the agency principles, particularly delegation, we can say that the delegation was proper and consent was implied. We now turn to the pertinent issue, whether Miss Rich and Vibes can lawfully claim to be a stranger to the bill of costs. Now, we note from the excerpt that Miss Rich and Vibes claims to be a stranger to the firm of Snoopy. What's the name of this firm? The name is Sweezy and Snoopy Company Advocates. Sweezy and Snoopy Company Advocates. This argument by Ms. Rich and Vibes is actually legally untenable and unsustainable, because in Omulele Tollo versus Mount Holding case, the court rejected the same exact argument that the retainer was with the old firm and not the reconstituted firm. That claim, that argument cannot be sustained. The court held that a client cannot approbate and reprobate. That is, accept legal services and later deny the advocate's right to legal fees. Applying this reasoning to the present scenario, Ms. Rich and Vibes accepted the services, she benefited from them, she communicated directly with Snoopy and did not object at any stage. Thus, her claim of being a stranger is barred by the principle of estoppel. You cannot approbate and reprobate, accept legal services, and later deny the advocate the benefit of enjoying the legal fees for the services rendered. Finally, there is it arises an issue of a rich aunt claiming that she had paid for these services, which is what we call the monthly retainer, the retainer that they had. But now another issue that comes again is now there is a competing interest whereby the advocates, Snoopy and the Snoopy and company advocates have now filed a bill of costs. So there are two competing interests. There are two competing arguments that Ms. Rich and Vibes used to pay the 250 monthly retainer, which in this case is actually a general retainer, not the one that is provided for under Section 45 of the Advocates Act. Now, in the Omulele Tollo case, the Court of Appeal clarified the difference between a retainer and a retainer agreement. These are two distinct things and they mean different things. So one, a retainer So we already discussed what a retainer is, which essentially can be instructions and or the fees payable under those instructions for, of course, for the advocate to be available when issues arise. However, a retainer agreement, and that retainer can be either oral, it can be in writing, or it can be actually through conduct. However, a retainer under Section 45 of the Advocates Act must be, and I wish that you open the Act and read Section 45, which provides that this retainer agreement, it has to be in writing, it must be signed by the client, which, if absent, the advocate retains the right to tax a bill of costs for the services rendered. So what we can infer from this section is that where there is no written agreement fixing fees exist, the monthly payment was for availability and not for conveyancing work. And actually, in the excerpt, that monthly retainer payments were for the availability of the advocate when issues as such arise. When issues of such nature arise. So I'm sorry, I had to catch up a glass of water, and now we are back. So where there is no, so absent such agreement, the advocate retains the right to tax a bill of costs. So no written agreement fixing fees exists. So in this case, there was no written agreement fixing the fees. And therefore, the monthly payment was for availability and not conveyancing work. Conveyancing is distinct and actually a chargeable transaction. Therefore, Sweezy and Snoopy company advocates are entitled to file and tax the bill of costs, as rightly observed in the Omulele Tollo case. Therefore, in the circumstances, the application by Miss Rich and Vibes should therefore fail. It should fail just like the application by Mount Holding failed in the Omulele and Tollo versus Mount Holding case, whereby they had filed an application stating that the bill of costs from this newly reconstituted firm of advocates was strange to them because they had not instructed them. And when that fails, the bill of costs filed by the Sweezy and Snoopy advocates, company advocates for that matter, should proceed to taxation in line with this authoritative holding in the Omulele and Tollo advocates case. With that said, we have now dissected this issue. We've had around 5 issues in this question, and that should now earn you 10 marks. That should earn you 10 marks. So in 5 issues, time 2 marks for each issue, then you get 10 marks. But there's one thing, and I will keep, and I'll insist, you have to read case laws, you have to read the Act. Because if you had not, if for an individual who has not read the Act, they could not, they cannot understand that there is a difference between the retainer agreement, which is a retainer agreement as provided under Section 45 of the Advocates Act, which is different from the common law retainer as we know it, which is more common law retainer being an agreement to, or instructions given to an advocate or and the fees payable thereunder. So it can be either instructions and the fees payable thereunder. But under Section 45 of the Advocates Act, a retainer agreement encompasses, it has to be, it's an agreement, yes, between the advocate and the client, but for the, so issuing instructions, it can have even costs or the monthly retainer payments. But the thing that separates these two is that it has to be in writing and it has to be signed. So if that were the case in this scenario, then Omulele Tollo, a claim to file a bill of costs could have failed, but that was not the case. So brethren, go and read the Omulele and Tollo case. And if you have any issues, any questions concerning the concerning a retainer agreements, you can always reach out to me in either the comment section to actually follow up so that we can discuss further. As you can see, we opened a channel, this YouTube channel, so you can also inform your mates, your friends to actually follow the account and like and share widely. With that said, I wish you all a lovely evening, and bye. We meet tomorrow.